I hope everybody's having a great summer vacation. This month I'm going to talk about the House case. Um, this particular case, the House versus the NCAA, was settled, and I'm going to explain as best I can the details of the settlement and how it's going to impact athletics in the future. If you happen to be a coach and you're looking for representation, please give me a call at 559-250-0151 or email me at jillbaxter@me.com. Many of my clients have had questions about what happened in the settlement between in the House case. And just so you know, this settlement actually resolves three separate antitrust cases. They are House versus the NCAA, Hubbard versus the NCAA, and Carter versus the NCAA, all from athletes claiming the NCAA violated the antitrust laws. The plaintiffs in these three cases are a Duke football captain, Dwayne Carter, joined by a Stanford soccer player, Nia Harrison, and a TCU/Oregon basketball player named Sedona Prince. I will specifically talk more about the House case, where Grant House, who's a former Arizona State swimmer, and Mr. Prince both sued the NCAA for barring NIL payments for athletes prior to 2021. Remember that in 2021, it's when the NCAA changed their rule to allow for student athletes to make money off their name, image, and likeness. So what is specifically the argument? Well, in the House case, both plaintiffs, House and Prince, say that the conferences, and this is the antitrust argument, say that the conferences work together with the NCAA to exploit the student athletes' labor and effort without legal representation, and also limited the compensation athletes can receive. In addition, they claim that the NCAA restrictions on NIL and control of TV markets prevents athletes from profiting on their true market value, which is more than scholarships and educational funding. A side note here is that what people do need to understand is that there is a statute of limitations on antitrust cases. They actually go back 4 years. So the settlement that took place has to do with student athletes who could have or should have earned money from their name, image, and likeness from 2016 to 2021. But the House case also deals with future revenue sharing with athletes, which is why you're hearing about the revenue sharing. So why would the NCAA decide to settle this case? It's very simple. If you do violate the antitrust laws and you lose, there's also a judgment for triple those damages. So the damages, the settlement that they ended up agreeing to is much less than what the potential amount would have been had they not settled the case. So what exactly now is this going to do? Well, let's dig into the settlement. First, the agreement, the first part of the settlement is for back pay or payment for work done in the past. So what they settled to is a $2.8 billion payment to be made over the course of 10 years. So it's geared to the current and former athletes as far back as 2016 that lost out on the possible profits from the NIL landscape prior to 2021. So that, just so you know, if you're a student athlete and you're listening to this, were you an athlete between 2016 and 2021, you may have some money coming to you. So here's where it got a little bit frustrating for how this money was going to be divided, this $2.8 billion payment in the settlement. The first thing is the NCAA would use its reserve funds set aside from its profits to pay roughly 40% of the $2.8 billion. So the NCAA is going to pay for 40%. The other 60% of the $2.8 billion is coming from the conferences. But this is where that division got a little bit different than what some conferences maybe weren't too happy about the result. Out of this, the 60%, the power conference schools, the ACC, the SEC, the Big 10, the Big 12, and the Pac-12 will take on 40% of that 60% of the $2.8 billion. And the rest is going to be shouldered by the non-power conference schools. So to give you an example, like the group of 5 conferences, think of schools like App State or East Carolina, and even non-FBS schools, those who don't compete in college football, pay a fraction. So, for example, a typical amount for maybe like an ACC school, which is a power conference school, the payment would be about $1 or $2 million total for the next decade, meaning 10 years. So interesting, though, is that the conferences will pay players by taking a chunk out of their future revenue from the March Madness tournament. So the NCAA pays conferences based on how many games its team played in the tournament, roughly $2 million for every game. And the conferences will use part of these future NCAA participation payments to fund the athlete payments. So even though football is the highest revenue generated sport in the NCAA because of TV viewership and ticket sales, basketball is the one that is going to help support the settlement because the NCAA has always earned a large sum of money off of its annual tournaments in March. Now, smaller conferences are a little bit upset because a smaller conference that maybe plays basketball uses that $2 million payment they would get probably to fund a lot of their athletic department, and they're going to be forced to pay a disproportionate amount of the settlement to mostly former Power 5 athletes. So that's where, to some, not all, the NCAA is bailing out the biggest spenders, and conferences like a smaller conference, like in the Ivy League, are paying for the majority of the settlement. Now, just so you understand, the sports economists are going to have to determine how the $2.8 billion will be split amongst the 10,000 former and current athletes affected by the settlement. But what has come up is that 90% of this $2.8 million will go to Power 5 men's basketball and football players. So these smaller conferences are kind of justified in their concerns. Now, what about future revenue? So that's how back pay is going to be dealt with. And some people are upset, some people aren't. At the very last minute, these other conferences tried to make it so that the Power 5 conferences were paying a higher percentage of the remaining 60%, but they went ahead and they did not agree with that analysis, I guess. So now here comes the more complicated part for what's going to happen in the future. The future is going to be revenue sharing, which is the other thing that in the settlement they have allowed. Now, just so you know, none of the conferences have worked out what this revenue sharing model is going to look like. However, but the proposal is that you create a spending cap of roughly no more than $22 million annually for each university, similar to what we have in professional leagues like the NFL, starting in the 2025-26 season. So none of this is going to begin immediately. It's not going to happen until 2025. So how did they come up with the 22 million? Well, the 22 million represents 22% of the average media rights, ticket sales, and sponsorship revenue of each power conference. Basically, each power conference school generates about 100 million annually in revenue stream. 22% of that is 22 million. So that's what they put as the cap. Obviously, as revenues increase, so could this 22% or $22 million figure. So now it comes down to how are they going to divide that 22 million? Well, in an athletics department, because of Title IX, there's probably going to have to be equal distribution amongst the men and the women athletes. And that's where each school is going to have to sit down and figure out exactly what that number is going to be. It just can't be over the 22%. So does that mean that all of a sudden athletes are going to become employees? The answer to that is no. What's going to happen is they're just allowing for revenue sharing, and they're also allowing and continuing to allowing, student athletes being able to make money off their name, image, and likeness. So it doesn't mean that it doesn't mean that collectives are going to go away. Now, what is going to happen is that like a new freshman incoming class that comes in is going to opt in or opt out of the future revenue agreement. If they opt out, they still have a right to sue. But if they opt in, they will not have a right to sue. So that's really why this settlement occurred, because in the current market or legal frenzy, there has been a lot of lawsuits, antitrust lawsuits against the NCAA. And what they're trying to do is trying to settle all that. Now, there's still a lot left that has to be decided. This settlement has to be approved by Claudia Wilkins of the U.S. District Court for Northern California, along with the plaintiff's attorney, and this could take several months. And how this revenue sharing model is going to work, I don't really have an answer to that. I can tell you that they're going to have to keep Title IX in while they're figuring out all of this. Title IX is going to be a factor. In addition, the next factor will be, so what you do have to realize, though, individual athletes and teams won't necessarily make the same amount. It's just the revenue sharing from the department will have to be equitable. But athletes will, like if you are like a quarterback and you're able to go and get more revenue for yourself, you will be allowed, you will be able to do that. Now, another thing that happened in this case is it eliminated scholarship limitations, because if you are restricting people, it gives the NCAA, if you prevent restrictions, then it prevents the NCAA from being sued on an antitrust case. So schools are going to have to decide how many scholarships they want per team, as long as it's within a roster limit. Now, this may end up benefiting baseball, because baseball's always had a very low amount of scholarships. I think it was 11.7, so they'll be allowed to increase their scholarships if they want to. And scholarships payments, just so you know, so another question has come up, is that going to be included in the revenue sharing? No, most scholarship payments will be made on top of the new revenue sharing requirements, which is why athletic departments, I think, will be really, some athletics departments may be really struggling as to how much they can afford. Now, if they decide in the final deal that some scholarships expenses from universities could count for the $22 million, that would probably be a advantageous thing to do for schools, certainly, that can't afford $22 million and the scholarship. So it's going to be really interesting to see how this all plays out. It's pretty interesting from a legal standpoint, but I understand why the settlement occurred, because it would have cost them possibly 3 times that amount of the $2.8 billion if they had not settled. And so I hope that helps explain everything. It's certainly, I think there's still a lot to iron out, and we'll see what happens in the future. Thank you for listening to this episode of Representation Without Taxation. Simply stated, I am always and forever about 3 things: protection, advocacy, and trust. To learn more about my fair fee structure, please visit my website at jillmcbridebaxter.com. If what we were talking about strikes a nerve, please subscribe and definitely share it. Until next time, it doesn't matter what the plan is, as long as you have one.